Thank you for your company and welcome back to the afternoon's program here at 4BC Brisbane 4RO in Rockhampton. It's time for the Legal Lowdown. As we know, Australia is in the middle of the biggest transfer of wealth in its history, with trillions expected to pass from one generation to the next. The lawyers are also warning that this massive transfer of wealth is fueling more disputes over wills, inheritance, and who should receive what. So I want to know what's behind the rise in these estate disputes and what families can do now to reduce the risk of a fight later on. We're joined by Attwood Marshall Lawyers, Estate Litigation Senior Associate Duncan MacDougall, to help us better understand what's happening in this space. Good afternoon to you, Duncan.
Nice to have me again.
You've been on holidays, you're back in the thick
now.
of it. We're talking wills and estates. I guess we're all familiar with the phrase, the great wealth transfer. But what exactly, I guess, does that mean? And what are you starting to see the effects of this in estate litigation and what you do?
Yeah, sure. So I think just over the last few years, you can see the property prices have increased dramatically, for one. The amount of wealth now that's coming down from the older generations to the younger generations is quite substantive. And unfortunately, that's generally a catalyst for litigation. The more they see dollar signs when people pass away. Obviously, we try to mitigate those risks and things like that prior to passing, but that's not always the case. So when you got a large sum of money coming into an estate to be distributed to multiple beneficiaries, all with different family dynamics, can create all sorts of issues.
With this transfer of wealth, something that I've noticed in my own, so anecdotally in my own life, is parents trying to get their kids ahead by giving them their inheritance ahead of time. How does that work in terms of structuring? Because it may not necessarily be cash. Are you remortgaging your house, or how are you then transferring that? And how does that become fair and equitable if there are multiple parties involved?
Yeah, sure. And it's an avenue that a lot of people are going down towards, where you see these almost early distributions to family members to try to avoid things blowing up down the track,
Right.
Make these sort of gifts now. Obviously, it's going to factor in terms of if things were to play out down the track and claims are made against the estate. A lot of it's not generally a disagreement about who loved mom and dad more. It's about who was treated fairly and equally. So when you see these big distributions already paid out during the course of somebody's lifetime, and then they try to get a second bite of the cherry, so to speak.
Yeah,
that's where you see a lot of claims come forward and a lot of disputes.
Yeah, I can imagine. And I mean, apart from the fact that there might be a larger estate or rising prices, something increases in value, that would obviously bring the risk of more conflict as well, I guess.
Absolutely, yeah. As those particularly around property, superannuation, another one we're seeing quite now as well. That starts to increase shares, other investments, But there may be instances where you can start to restructure your assets to, I suppose, mitigate those risks down the track.
What are the more common, I guess, disputes that arise in a family situation, I guess, after someone dies? One of the questions that I've never really had answered is when a family member passed in our life that had a lot of debt. I've never had the answer to the question of, does that debt get then inherited on by the people that may have been in a will? Do they also have to take on the financial risk as well as the reward?
No, in that case, no. So what's going to happen is that at the time of distribution, depending on what debt or liabilities there that the deceased may have, all debt, liabilities, and estate expenses have to be paid out before distribution takes place. So before anybody's getting an inheritance, these debts have to be paid. And even when you're administrating an estate, certain notices go out to the world at large to say, for instance, before you make an application for grant of probate. So that's that court stamp of approval, confirming a will, approving the executor to administer the estate. It says, well, if anybody's going to make a claim, come forward now. So the executor is aware of that to take that into consideration at the time of distribution.
Because then what are the sort of more common sort of family situations where a dispute may arise, particularly if everything is been written down, I guess, or it seems above board.
Yeah. There's a multitude of different factors. It's not just a one-size-fits-all, I think. You see a lot of, particularly the work I'm in, a lot of sibling disputes, different family dynamics where there might be step kids, there might be adopted children, there might be estranged children that have come out from the woodworks. There's also instances, we're living longer as well. So people are holding on to their wealth a little longer than what they did in the past. Mm-hmm. So it's a big lump sum at the end. And other sorts of things. The cost of living now as well. There's a little more financial pressure for everybody, which just is, again, that more incentive to see these dollar signs and say, hey, listen, I think realistically now, I think a lot of people are a little more aware of their rights to make these sorts of claims.
Right.
So why not give it a shot? See if you have any right there. But I will say not everybody who can make a claim is going to be successful in a claim. And it comes down to a multitude of things a court would look like at in those circumstances, including the size of the estate, the nature of the relationship, their financial position. Can they actually demonstrate a need for further provision? Mm-hmm. Things like that.
You can text through anytime you like. A question if you have for Duncan here from Attwood Marshall Lawyers, 0499 880 882. Of course, you can email through as well, afternoons@4bc.com.au. John from Springwood is asking, does a will need to be registered or authorised with any bodies, or can it just be signed and witnessed by two parties?
Yeah, so fortunately there's no centralised will registry, so it's important to make sure you get your will done presumably in front of a solicitor who knows what they're doing. Mm-hmm. They ask the right questions. Make sure you're actually including everything in your estate, making sure you have a clear understanding about what's going to go where, what you have in your estate, the risks to your estate. Generally speaking, that should be held somewhere safe, either in their solicitor's safe custody. The ones that we try to avoid is those do-at-home ones where...
I was going to say, the online ones.
Yeah, the online ones where they keep it in a safe, but we have all sorts of issues when that comes into play there because it might not have been witnessed properly. It may not have been signed correctly. There could have been testamentary issues where they may have not had capacity at the time of preparing their will. And when it's stored at home, you never know what can happen. And when we're relying on an original document, when we're relying on copies, it just creates a multitude of issues.
Because that's the other thing I was going to ask. Like, a solicitor might be a bit cost prohibitive, or you may not think you've got, a witness by these two parties or a witness properly. Can you just write it on a serviette if it's witnessed properly, or is that fraught with danger?
It's fraught with danger. I've seen too many issues where the cost, I know some people try to avoid the costs of seeing a lawyer.
Yeah.
And sometimes I don't blame them, but at the same time, what you're going to be paying and what your estate's going to be paying down the track
in the long run
far outweighs any sort of cost to get it done right in the first place.
What just ballpark figure me because I haven't done my will. Not that I'm worth anything.
Yeah.
But if I was just to have a quick meeting, this is what I've got.
Mm-hmm. It's a very straightforward estate,
what sort of things do I have to bring you receipts?
Yeah,
no.
So the biggest thing is making sure that you have a clear understanding of your assets and liability and any sort of liabilities.
Okay.
Your family dynamics, and everything, superannuation.
You don't want my family in that meeting, Duncan.
No?
If you want to see family dynamics, we put the fun in dysfunction.
Oh, great. Well, I tell those people with those sorts of family dynamics, I know it might be very hard to have those conversations before you pass away.
Yeah.
Because you're really a balance between expectations versus what's actually on paper. Mm-hmm. So when people are less surprised down the track, the less fights they're probably going to be. Okay. Or more of an indication, okay, well, we are expecting this to happen. What can we do about it?
Okay. Have you ever had a situation where now my only reference is in a movie, but you read out a will and there's like a surprise, estate, someone's left something to a hairdresser or whatever it might be. Have you ever done one of those readings where that's happened?
The reading of the will, that's a very much a Hollywood
again, like thing. I said, my reference is a movie, Duncan.
But that being said, by all means, sometimes some people see an inheritance. They get a notice from an executor saying you're due to be to inherit something. That's a big surprise. When they eventually contact beneficiaries, and but they're only obligated to contact the people who are included in the will.
Right,
so
of course.
Through the grapevine, if somebody believes they've been not provided for under a will, it's important to act as soon as possible.
Yeah.
Reach out, because you've got certain limitations in terms of your rights there, in terms of bringing any sort of claim against the estate.
Okay. The only other reference that I have is landing on community chest on Monopoly.
Okay.
And getting a card, and I've inherited something. Very quickly, lastly, Duncan, there's a question here. Anonymously, 3 siblings are set to receive a substantial inheritance. What is the time limit for the executor to notify the solicitor that someone has died? Additionally, once the inheritance is distributed, are they liable for any taxes?
Yeah, so great question. I mean, as an executor, it's all going to depend on the size of the estate, the nature of the estate. Generally speaking, if we're administrating an estate, we advise the executor, let the beneficiaries know as soon as possible that they are included under a will. But that being said, any sort of distributions shouldn't be taken place before 6 months from the date of death. The reason being is that within those 6 months, somebody can bring a notice of a claim. And if an executor makes any sort of distribution within those 6 months, then receives notice of a claim, they could be personally liable for those distributions.
Okay, so wait 6 months.
Wait at least 6 months, yeah.
At least.
Yeah. And then if you're making a claim and provided you have not been provided for, provided you're at least in Queensland, a spouse, including a de facto spouse, children, stepchildren, dependents, certain types of dependents, you've got 9 months from the date of death to actually file your application with the court.
Okay. Oh, so much information. I hope this has been helpful and answered your question as well. If you've got more that you'd like to get through, we've got to let Duncan go now, but email us afternoons@4bc.com.au. We'll see if we can get them through to Duncan before he comes in the next time. Thank you so much. I always appreciate when you stop by. It's fascinating what you do.
Thanks for having me again.
I've got to stop watching movies.
That's a ticket.
Duncan MacDougall there from Attwood Marshall Lawyers.